Good day everyone, especially to you sir. My name is Sarah Jimo Salita Adahar, a third year criminology student. My topic is all about development of scientific crime laboratory in the Philippines. February 14, 1892, massacre occurred in Chicago. Then a group of public-minded individuals was responsible for the establishment of a scientific crime laboratory in the city, which they has marked its place in the historical annals of police science. March 31, 1876, creation of medical titulars by virtue of Royal Decree number 188 of Spain. For every province, a forensic physician was assigned to perform public sanitary duties and at the same time provide medico-legal aids to the administration of justice. December 15, 1884, Governor General Joaquin Chavilar created a committee to study the mineral water of Luzon and appointed Anacol to Del Rosaria as chemist. September 13, 1887, establishment of laboratories Municipal de Manila under the inspection of the Direction General de Administration Civil and the control of the Gobierno de Provincias. The function of the laboratory was to make analysis not only of food, water, and others from the standpoint of public health and legal medicine, but also of specimen for clinical purposes. 1894, Laboratory Medico-Legal was created under the dependency of the judicial branch of the government and laboratory, functioning under the direction of physician and assisted by a pharmacist and chemist. 1895, Antonio Lona established a clinical laboratory where some original works in chemistry were done. Unfortunately, all prospects of the advancement of the scientific laboratories were paralyzed as a result of the revolution in 1896. 1899, the first scientific laboratory was established in a small building on the banks of Pasig River with strong of the U.S. Army in charge. 1901, actual scientific work began under the initiative of then C. Worcester by virtue of Act Number 156 approved by the Civil Commissions. July 1, 1901, the Bureau of Government Laboratories was created for the purpose of performing biological and chemical examinations as well as the production of vaccines and sera. March 11, 1915, the Department of Legal Medicine was created pursuant to the resolution of the Board of Regents. The department took charge of the courses of legal medicines and its branches in the College of Medicine and Law. October 14, 1924, through the passage of Act Number 3043 by the Philippine Legislature. The same Department of Legal Medicine became a branch of the Department of Justice and that at the same time an integral part of the University of the Philippines. December 1, 1937, the Division of Investigation was created under Commonwealth Act Number 181 with 2 medical legal officers and a chemist. The medical legal section of the Division of Investigation started the definite movement towards the creation of scientific crime detection laboratory. September 1945, the National Bureau of Investigation or NBI was organized with the Division of Investigation as the nucleus. The chemical laboratory of the medical legal section was expanded into a forensic chemistry division. At present, there are 4 distinct laboratories in the Philippines performing forensic chemical analysis. First, Forensic Chemistry Division of the NBI. Second, the Criminal Investigation Laboratory of the Manila Police Department. Third, the Criminal Investigation and Detection Laboratory of the Philippine Constabulary. Fourth, Manila Investigation Service Laboratory. Scientific evidence. Evidence is a proof of allegation. It is a means sanctioned by law of ascertaining in a judicial proceeding to the truth respecting a matter of fact. Section Rule 128, Revised Rules on Evidence. Corollary thereto, scientific evidence may be defined as the means sanctioned by law of ascertaining in a judicial proceeding the truth respecting a matter of fact wherein scientific knowledge is necessary. Such scientific evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence may be A. Direct, B. Indirect, which includes circumstantial evidence, and C. hearsay. Direct evidence is which the sense perceive any fact to which a witness testified based on what he saw, heard, smelled, touched, or tasted. It's direct. Crimes are done secretly. Usually, the perpetrator seeks darkness and remoteness in order to cover his misdeeds, and in most cases, no witness is present at the scene of the crime, or even if there is or are witnesses, they are not willing to testify. The necessity of resorting to other means of proof is essential, hence it is necessary to use all other available modes of pursuing evidence in order to establish and prove a case in court. B. Circumstantial evidence is a kind of evidence which seeks to establish a conclusion by inference from the fact proven. While a policeman was strolling, he heard a scream from a house. He immediately proceeded to the house, and there he saw a man coming out of the house carrying a bloody knife. The policeman arrested the man and subsequently entered the house. There he saw a female cadaver lying on the floor with a stab wound on the breast. In this case, the only direct evidence to which the policeman can satisfy would be to the fact that he saw the man with a bloody knife coming out of the house wherein the scream came from. The prosecutor was established a conclusion that the man with the bloody knife is the criminal by inference from the fact testified to the policeman. Under the present law, circumstantial evidence is sufficient for conviction if there is more than one circumstance. Second, the fact from which the inferences are derived are proven. And the third, the combination of all the circumstances is such as to produce conviction beyond reasonable doubt. C. Hearsay evidence is a statement made by a witness on the authority of another and not from his own personal knowledge or observation. Hearsay evidence is inadmissible except on the following. 1. Dying declaration. 2. Res gestae. 3. Declaration against interest. 4. Act or declaration about pedigree. 5. Family reputation or tradition regarding pedigree. 6. Common reputation. 7. Part of res gestae. 8. Enters in the course of business. 9. Enters in official records. 10. Learned treatise. And the last but not the least, 11. Testimony or deposition at a former proceeding. Forms of scientific evidence. First, real or autoptic evidence is that evidence which is addressed to the senses of the court. It is not limited to that which can be known by the sense of vision, but extend to those which are perceived by the senses of hearing, taste, smell, or touch. Second, testimonial evidence. An expert may be called on the witness stand to answer all questions propounded by both parties in the case. Third, documentary evidence. Any written evidence presented by an expert in court which is relevant to the subject matter in this and not excluded by the rules of court. Formal written report, expert opinion, certificates, and dispositions are included in this. The investigator is a fact finder. It is basic that he must know the laws concerning the nature of his investigation, he should pursue evidence in such a way that the findings can be admitted in court and remain impregnable against any attack by the opposing counsel. He should be in constant contact with various investigative and enforcement agencies. Practice of forensic chemistry. The work of a forensic chemist is divided into 4 stages. First, collection or reception of specimen. Second, the actual examination. Third, the communication of the results of the examination. Fourth, court appearance. Collection of the specimen to be examined. The proper collection, preservation, and transportation of specimens are essential in the investigation of a crime. Hence, whenever possible, the chemist should personally collect all the specimens necessary for the examinations. This particular stage of a forensic chemist work is essential as questions regarding the collection, preservation, and transportation of the specimen are raised during the trial. Factors that must be considered when collecting specimen for examination. First, sufficiency of samples. Such much as possible, the investigator should collect sufficient amount of specimen for examination. This will make the chemist confident that in case of doubtful result, he or she can still have enough samples to repeat or to proceed to the succeeding examinations. Second, standard for comparison. When the evidence is questioned, is located in or added with the foreign substance, a sample of such foreign substance must be submitted for analysis. For instance, of blood is found on linoleum, a sample of the unstained linoleum must be submitted together with the stained portion. In cases of adulteration or unfair trade competition, a genuine sample must be submitted for comparison in the examination of hair, textile, fiber, soil, and etc. Standard samples must be submitted for comparison. Third, maintenance of individuality. Each piece of evidence must be collected and preserved as a separate sample. There must be no mixing or intermingling of specimens collected from different locations, as well as those of standard specimen. Fourth, labeling and sealing. It is a well-settled rule that evidence will have no value in court in spite of the good report of the expert if the specimen cannot be identified by reason of improper labeling. Hence, each sample must be labeled properly. Small fragments should be enclosed in proper specimen boxes or container, and the boxes should be sealed. The label should include information concerning the nature and source of the sample, date and time of collection, case number, if any, and name of the person collecting the sample. Actual examination of the specimen. The first step in the examination of an article is to scrutinize it carefully and write down on the laboratory logbook or record book a complete description of the external appearance, including the manner in which it is secured and the particulars of the sealing of possible take a photograph of the specimen, including the inner wrappings, and take note of its descriptions. A detailed description of the appearance of the contents of the package should be noted and recorded. All wrappers should be kept and preserved since questions concerning them may be raised in court during trial. The second step in the examination is to measure or with the object, and all measurements and widths should be entered in the laboratory logbook or record book. The specimen should then be placed in the proper container or wrapper and must be kept in the proper evidence room. The third step in the laboratory examination, which consists of the chemical, physical, and confirmatory test. Communication of the results of the examination. The results of the examination conducted should be communicated with the requesting party in the form of a written report, which must include an enumeration of facts on the specimen reserved for examination, with detailed description of the packaging, sealing and labeling, date of receipt, and from whom it was reserved, the purpose of the examination, the finding and conclusion. Court appearance. The written report of the forensic chemist is usually supplemented by testimonial evidence in a later date if the case is brought to court or the fiscal's office since the testimonial evidence may be given weeks, months, or even years after the examination and the written report have been made. It is not only permissible but indispensable that the chemist should refresh his memory by referring to his laboratory record book before presenting himself in court. Role of forensic chemist in the scientific investigation. Forensic chemist, as a man of science, performs laboratory examinations on physical evidence submitted to the crime laboratory in order to expedite the investigation of a crime by the investigating party. He or she has the following responsibilities. Number 1, conducts qualitative and quantitative determination of abuse drugs as well as volatile substance. Second, conducts chemical examination of explosives and or explosive ingredients. Third, conducts examination of paraffin cast and firearms to determine the presence of gunpowder nitrates. Fourth, conducts gunpowder examination on clothing for possible gunshot range. Fifth, conducts chemico-toxicological examination of human internal organs, gastric contents, blood, water, food sample, and other substance. 6. Conducts examination of fake products in cases of unfair trade competition. 7. Conducts blood alcohol determinations. 8. Examines urine samples and other body fluids for the presence of abuse drugs. 9. Conducts researches related to cases being examined. 10. Testifies and giving expert opinion in a court. 11. Gives lectures on forensic chemistry and chemical toxicology to various schools, universities, police training centers, and investigating units. 12. Responds to queries of all investigating units and render expert opinion on matters related to the application of chemical principles for the purpose of assisting investigators to develop investigative leads. There are 6 golden rules in the practice of forensic chemistry. First, go slowly. Good work cannot be hurried, therefore, take all the time necessary to make the case complete, no matter how urgent it may appear. Second, be through. Make careful and minute examination of everything and do not be satisfied with a quantitative analysis if a quantitative one is possible. It always pays to do too much rather than too little, and it is difficult to foresee what will or will not be required in court. Third, take notes. Keep a full, neat, and clean record of everything seen and done. Fourth, consult others. Many cases will lead the expert into paths with which he is not familiar, and when his happiness he should consult those who know better. Fifth, use imagination. An expert with a wide and uncontrollable imagination is considered as the most dangerous creature. Through his being imaginative is sometimes useful. An expert witness does not have to be solely imaginative, but he has to be skilled in the field of forensic science. He must bear witness within the limits of science. Last but not the least, number 6, avoid complicated theories. The simplest explanation is fundamentally the right one. Interpretation of results is often the most difficult part of the expert's task. That is why a wide knowledge and scientific experience are the essential elements to obtain the right forensic examination results. Equipments used to the forensic examination. The following are some of the most common laboratory equipments used in forensic examination. 1. HPLC, or high-powered liquid chromatography. This scientific equipment is used for the qualitative and quantitative determination of a volatile or non-volatile compound based on the chromatographic separation of its components. Second, ultraviolet spectrophotometer. It is used for the qualitative and quantitative analysis for organic compounds. Third, EMIT, or enzyme multiple immunoassay technique. It is used for screening of abused urine sample. Fourth, SEM, or scanning electron microscope. This scientific equipment is used for the physical identification of various questioned specimens. It is a software-controlled digital scanning electron microscope used to produce sticking image over a wide range of magnification on through or covered surface of minute specimen. such as hair fibers, paint particles, drugs, metal, and etc. Fifth, FTIR or Fourier transform infrared spectroscopy, used for the identification of pure organic substances. It identified organic substance, particularly abuse drugs and explosive ingredients based on their characteristic functional groups. In layman's term, the result spectrums could be referred to as the fingerprints of the substance. Witness defined. A witness in court may be an ordinary or expert witness. Under the law, an ordinary witness must have the following qualifications. First, he must have the organ and power to perceive. Second, perceiving can make known his perception to others. Third, he does not fall in any of the exceptions provided for by law 1, 2, 3 rules of court. The opinion of a witness regarding a question of science, art, or trade, where he is skilled therein, may be received in evidence. This kind of evidence is called the testimony of an expert witness. Distinctions between an ordinary and an expert witness. Ordinary witness and expert witness. Number 1 can only state what his senses has perceived. Expert witness state that he has perceived and also give his opinion, deduction, or conclusions to his perception. Ordinary witness 2 may not be skilled on the line he is satisfying. Expert witness 2 must be skilled in the art, science, or trade he is satisfied. Third, cannot testify or things which he has not seen by giving his opinions, deductions, or conclusions on the statements of fact. Probative value or expert testimony. Whether courts are or are not bound by the testimony of an expert depends upon the nature of the subject of inquiry. If the subject of inquiry comes within the general knowledge of the judge, the latter will not be bound by the conclusion of the expert. For instance, when the subject of inquiry is genuineness of a handwritten as compared to a standard. However, when the subject of inquiry is of such as a nature that a layman can have no knowledge thereof, and as of instance, the determination of parentage through DNA test. The court must depend on the result of the examination of an expert. Qualifications of an expert witness. First, the degree of learning of the witness. Second, the basis and logic of his conclusions. And third, the other proof of case. Drug. Drug defined is a chemical substance that brings about physical, physiological, behavioral, and or psychological change in a person taking it. All medicines are drugs, but not all drugs are medicine drug. Medical drugs. A substance which, when taken into the human body, cures illness and or relieves signs or symptoms of disease. Dangerous drug. A substance affecting the central nervous system which, when taken into the human body, brings about physical, emotional, or behavioral changes in a person taking it. Drug abuse. Any non-medical use of drugs that cause physical, psychological, legal, economic, or social damage to the user or to people affected by the user's behavior. Abuse usually records to illegal drugs, but may also be applicable to drugs that are available legally, such as prescribed medications and certain over-the-counter medications. Classification of drugs. According to the origin, natural drugs are active ingredients, secondary metabolic products of plants and other living systems that may be isolated by extraction. Example, raw opium, marijuana, and coca bush. Synthetic drugs are artificially produced substances synthesized in the laboratory for the illicit market, which are almost wholly manufactured from chemical compounds in illicit laboratories. Example, methamphetamine and barbiturates. According to the legal classification, Article 9165 Comprehensive Dangerous Drug Act of 2002. PD 1619 Volatile Substance. See Article 6425 classified as regulated and prohibited. Under Article 9165, otherwise known as the Comprehensive Dangerous Drug Act of 2002, the term prohibited and regulated was changed into dangerous drug with the following classification. Immediate precursors, a chemical substance used in the manufacturing produce becomes incorporated in full or in part into the final molecules of an substance under international control. As reagent or solvent in the illegal manufacture of controlling substance. According to international classification, A. Narcotic substance, B. Psychotropic substances, C. Designer drugs. According to pharmacological classification or effects, A. Stimulants, B. Hallucinogens, C. Depressants, D. Inhalants. Stimulants are drugs which increase alertness of physical exposure. Example, amphetamine. Street name eye opener, lead poppers, peep pills, uppers, hearts. What it is: reduces appetite, relieves mental depression, comfort, fatigue, and sleepiness. How taken? Orally as tablet or capsule. Effect: general wakefulness, increased alertness or initiative. And that's all for today. Thank you. Goodbye.